Good morning and welcome to the Historic Courthouse. We have three cases on today's calendar: Evans v. United States, Simmons et al. V. Jackson, and Johnson v. United States. We're going to call Evans v. United States first, 24 CM 724. Is council ready to proceed?
Thank you, Your Honor. This is the case of the homeless person who was suffering from severe pain in his
Mr.
feet.
Cohn, if I could just stop you for a brief moment. If I could ask you to identify yourself for the record to start with, and let us know if you want us to save any time for you for rebuttal.
Sure. Thank you, Your Honor. I'll save 5 minutes for rebuttal. My name is Timothy Cohn, appointed by this court to represent the appellant Evans. And as an additional, Lisa Resnikoff wrote the initial brief in this case, but I was appointed after that. This is the case where the homeless person was suffering from severe pain in his feet, fungus, calluses. His probation officer sent him to the hospital. At the hospital, he demanded new shoes for his feet after the hospital hosed him down and essentially destroyed his shoes or severely damaged them. That's an important fact in this case because it shows first that he was suffering from imminent harm, pain to his feet.
Mr. Cohn, can we back up a little bit? Do you have a view on whether this court has decided who bears the burden of showing necessity or a burden of proof of establishing necessity? And if so, who bears it?
Good question, Your Honor. That question is not addressed in the briefs directly. The initial brief cites a Massachusetts case that applies the reasonable doubt standard that says that the government, the state, the Commonwealth must disprove necessity beyond a reasonable doubt.
But before we get there, necessity has to be established by some standard, right?
Yes, Your Honor. The typical standard is enough evidence has to be presented to trigger the defense. So that's the standard that we argued for in our brief, that once enough evidence is presented to trigger a necessity defense, the government bears the burden of disproving that beyond a reasonable doubt. The government did not challenge that in its response brief, in its motion for summary affirmance. Accordingly, in effect, waived that issue and didn't argue, oh, no, the defendant has, say, a preponderance of the evidence standard applies, and which some courts, especially the federal courts, have occasionally applied. So our view is that the way the case is presented, in this case, the question is whether the government disproved beyond a reasonable doubt.
So you're relying, I know you didn't write the brief, but your client relies on this Massachusetts case and perhaps other out of jurisdiction cases, but do you not think that we've decided it? And I'm thinking particularly of the Emery case.
Of which case, I'm sorry?
Emery, E-M-R-Y.
Right.
I mean, and if you don't know that case offhand, is it generally your position that this court hasn't decided it definitively?
That's my impression from the case law, Judge. And I worry, honestly, at getting, it's an interesting question and an important question, spending time at oral argument on an issue that was not briefed by either party, fully briefed. Actually, we raised it. Reasonable words, reasonable doubt are in our brief, so it's preserved in that sense on appeal. But the government has not argued a preponderance standard. I don't think the word preponderance is in its brief, so I hesitate to argue, although it is, I acknowledge, an important question. Although, in my view, in this case, the court could say, regardless of the burden, here the defense clearly should prevail for the reasons I was beginning to say. It showed an imminent harm, the feet, and the evidence is clear. They demanded new shoes at the hospital, was turned down. Went to the PIW donation bin looking for shoes. Again, clearly the harm was continuing. And again, he was trying to avail himself at every opportunity
Well,
of
counsel,
a
to
way.
clarify before you go too far down that route, would you agree that it's a fair reading of the trial court's findings that it didn't even get to that stage of proof? That what essentially the trial court did was say that it didn't believe the evidence was sufficient to make out the prima facie case of this because it didn't buy the eminence, nor did it buy that there weren't alternative options?
Honestly, I'm not sure. It's a one paragraph discussion and one could go either way. My own personal reading is no, the judge actually didn't say what you just said, Judge Howard. The judge actually credited the defense testimony, credited the facts that the defense had put, and then said, I don't find imminence, as you just said, Your Honor. So my view is that it didn't reject the necessity defense, which would have been something the court could have said pretty clearly. I reject this defense. I find it inapplicable, and we have cases like that. To my mind, the judge was applying the defense, recognizing that it applied, but finding on imminence, as Your Honor stated, had only on imminence, that the evidence was not sufficient to.
But Mr. Cohn, so I mean, I won't take us back to burden, but it's gonna ultimately play an outsized role here. But my understanding is that a defendant has to prove the three factors of necessity, or they have to be established at some point. And so if we were to agree with you that the trial court made some errors here on imminence and whether the shoes that Mr. Evans took were reasonably designed to alleviate the harm, that there were some errors there. There was still a third factor, that whether there was a legal alternative. And I'm having a little trouble figuring out whether the trial court addressed that or implicitly addressed it or neglected to address it. But if your client failed to establish that third element, if we accept that the burden falls on him, then he would lose on that ground too. So what's your take on that?
Yes, Your Honor. We agree that the judge did not really reach the legal availability prong. I think he was just relying on Judge Howard was suggesting on evidence. What I was beginning to say as at the very top was I think this is a clear case of having established trying to exhaust all legal available options before. And the three that I would point out to Your Honor is first, that at the hospital, he demanded new shoes for the shoes that had been destroyed, tried to get that first there. When he was sent to PIW, he went to the donation bin at PIW, did not find shoes, but again, trying to avail himself of a legal available option. And finally, when he went to the shoe store, he went to the clearance section. And that's all in the record and it's in our brief. So again and again and again, this defendant tried to avail himself of legally available opportunities to alleviate the pain, the severe pain. He said his feet were on fire that he was feeling. We feel.
Excuse me, you used the adjectives both destroyed and damaged to describe the shoes. Was there any problem with the shoes other than his original shoes, other than the lack of an insole?
I believe so, sir, Your Honor. I think they lacked actually soles, or at least one of them did. It's in the record, and I'm happy to
Okay.
go back to
Okay.
the brief and the description of the shoes. But they were somewhere between destroyed and severely damaged. Let's
Okay.
put it that way, especially for someone who has been sent to the hospital for his feet and his foot pain to be taken care of.
I mean,
And
the
how
trial
much-
court, sorry, go ahead.
I hope a quick question. How much time does the record show elapsed between Mr. Evans' discharge from PIW and his arrival at DSW at the shoe store?
The record doesn't show the exact time. It does show that he got on the first bus that he could, okay? The world being a small place, I live a block away from that bus stop, so I can invite the court to take judicial notice of the fact that that bus stop is right in front of PIW. And the bus runs to Columbia Heights directly. So it would have been the time a bus takes to go from that stop in Tenleytown to the Columbia Heights station. And the DSW store is across the street from that metro
But
station.
I thought he did some panhandling when he
Right.
arrived.
And the record doesn't show how much time he spent panhandling, so we don't know exactly how much time. But I would say, Your Honor, that time spent panhandling is not evidence that, contrary to the trial court's view, undermines the imminence of the pain that he was feeling. The panhandling was because he had no money, he was hungry, and he conceivably, if he'd gotten enough money, he could have got enough money to buy a $42 pair of Sperry soles.
Was there anything in the record to indicate that he was aware of the DSW before stumbling upon it?
No. So if there are more questions from the court, I will stop. Judge Schenker, I don't want to avoid your understandable question about the burden here. It just wasn't fully raised. What I can add is that in the brief, the initial brief quotes the defendant saying that his action at DSW was impulsive and a reflex action. And that language is very similar, if not identical, to the self-defense defense that juries are instructed on. If the defendant is acting impulsively in view of a threat that he feels, in that situation, the self-defense defense applies. And in that respect, the two defenses, necessity and self-defense, are quite similar. For the sake of credibility, though, I will add that necessity has been viewed in the cases as a public policy defense, as one that looks at the balance of harms for society. And to that extent, it's a different kind of defense. But it's a difficult question. I'm sure a lot of jurists before Your Honors have wrestled with it, and it's not raised in the government's brief.
I mean, the other, I'm cutting into I'm not intending to cut into your rebuttal time. I don't think I will be. But the other reason they're different is because or at least with respect to murder, self-defense negates the intent mens rea of the crime because murder requires malice aforethought. Now, we've extended the self-defense burden shifting framework to non-murder crimes, and courts throughout the country have done that. And whether that's correct or not, I don't know, but that ship has sailed. Necessity and duress do not negate the mens rea of the crime. So that's where this difficulty in who bears the burden arises, in my view, at least. But I think this is a question that obviously the government will have to answer too. So.
Right.
Can I just ask the part, I'm going back to my day job. How is a trial judge supposed to balance the imminent harm, the necessity for the defendant, and determine whether it substantially exceeds the costs? I mean, your apples and oranges doesn't begin to
cases
describe.
that cut our way on this issue, which are the cases I would refer the court to, are the Commonwealth Magadini, Massachusetts case, where the court, and in this case it was a court of appeals, said the harm to a homeless person of being out in the cold on a really cold night, their words, exceeds the loss to society of the violation of the trespass law that the homeless person, the law that the homeless person violated by going inside. So courts are able to make this kind of balance. And in this case, the evidence was very, very, very strong that the imminent harm, the pain outweighed the $42 theft of Sperry souls.
I was going to ask you where you draw the line, and I think that you've given somewhat of an answer. You've given an answer there. Let me ask you, since you were comparing self-defense and necessity, would you agree that necessity and duress are probably the two most interrelated, and that in our case law, we've often fudged the defenses for one another?
I acknowledge that, Your Honor. They are similar, yes.
And you think it would be fair to borrow from duress when looking at necessity?
If, I would prefer self-defense, but yes, I think, and, you know, the Judge Chanker, I'm over my time, but Judge Chanker made the point that one defense negates mens rea and the other does not. And that's a point that some cases have made. But I think once you probe a little deeper, it gets very confusing whether, in fact, take our case, did he really have the mens rea of a thief, given or was his action to relieve the pain in his feet impulsive and a reflex action rather than I intend to steal shoes? It gets confusing.
All right, if there's no further questions, thank you, counsel. We reserved your time for rebuttal.
Thank you.
Mr. Brock?
May it please the court, Matthew Brock for the United States. Judge Schenker, if I can start with the question that you had asked as to the burden. This court has clearly stated in Emory that there is an initial burden of production that the defendant needs to establish. I don't believe this court has ever specifically stated the standard by which that burden needs to be established. The one that I believe is most commonly used, it was used, I think, most recently in the Ninth Circuit. In the Powers case that we provided the court by the 28K letter, is by a preponderance of the evidence. Then the burden would shift as an affirmative defense then to the government to disprove beyond a reasonable doubt. However, in this case, Your Honor, the trial court made factual findings and found that the defendant had not established, that Mr. Evans had not established each of these three elements that was required of him in order to establish the necessity defense.
Okay, so sorry, I want to hear where you're continuing to go, but just so I'm clear where we are as a starting ground, the government concedes, or I don't want to say concedes, that's a loaded term. The government agrees that necessity carries the same sort of burden shifting burden framework as self-defense, which is that the defendant has to come forward with some level of evidence to have the defense at play. And then the burden shifts to the government to prove its absence beyond a reasonable doubt.
That is the government's understanding from the Emory case, Your Honor. I think the Emory case pretty clearly states the language that the initial burden rests on the defendant.
Okay, and then so your position, sorry, just clarify real quick. So your position is that the trial court's view was that Mr. Evans had not established the first level of even presenting sufficient evidence to shift the burden.
Your Honor, I don't think the trial court was particularly clear. I think it would require some level of speculation on our part as to whether the trial court seemed to assume without deciding that it would instruct itself on the necessity defense and then determine that whether or not the necessity defense not only just applied, but whether the defendant had met the burden.
Okay.
And seemed to decide it sort of all in one.
I just want to make sure I understand, because what you first said was that the defendant's initial burden is to prove necessity by a preponderance of the evidence. If the defendant proves necessity by a preponderance of the evidence, there's no way the government can disprove necessity beyond a reasonable doubt. I mean, because, reasonable doubt requires proof by a lot more than a preponderance of the evidence. So are you backing off of that and now saying the defendant's initial burden is only to prove kind of analogous to the self-defense context, some evidence of self-defense, and then that kind of, then the defense is in play and the government has to prove beyond a reasonable doubt that the defendant did not act out of necessity.
Your Honor, if I can just make sure I understand your
Yeah.
question. It's that the defendant must, in order to indicate, obviously this is a bench trial, but in the case of a jury trial, there must be a level of evidence that the defendant must present in order for the jury to be instructed on necessity.
Right.
And at that point, the necessity defense is now in play such that it can be argued. But as with somewhat similar to self-defense or duress, where at that point the defense is now in play, but it is still an affirmative defense that then there needs to be evidence affirmatively showing.
Okay, but then if it is in play, then does the government have to prove beyond a reasonable doubt that the defendant did not act out of necessity?
I don't believe that there has specifically been any case law in this jurisdiction that has addressed that question.
But you're,
Okay,
but you
then-
just said your position was that the government's position is that that is the case, right?
That would appear to be the most analogous.
You're combining Powers with Emery, right?
Yes, Your Honor.
And that's how you're getting there. And what Judge Epstein was asking you, which I found interesting too, is that if something is proven by a preponderance of the evidence at one stage, then it seems definitionally incompatible to go beyond a reasonable doubt, like that the government could do that. But what I want to draw you to as well is in Emery at 973, you know, it uses that language. Since necessity is an affirmative defense, the burden was on Miss Emery to put forth sufficient evidence to satisfy the Griffin factors. And the C also includes a parenthetical, the defendant must bear the initial burden of producing evidence which could support a finding in her favor on each element of the defense. And so that doesn't quite seem like a preponderance. It seems like making out a prima facie case, a kind of lower burden of production. And then would you say it switches to the government there? How does the preponderance versus beyond a reasonable doubt play into this? And I'm sure I've just confused this all more.
The beyond the reasonable doubt is obviously the ultimate burden in this criminal case for the government. And the burden ultimately rests on the government. But when the government's burden is to establish, in this case, the theft charge, when the defendant is then asserting a affirmative defense, such as duress, defense of necessity, there is, as Your Honor notes, the initial burden of producing the prima facie case to reach the level of instruction, at which point the defense then comes into play for the finder of fact.
But I understand Powers to treat the necessity defense kind of like the insanity defense. In the insanity defense, the defendant has the burden to prove that he's not criminally responsible. Then if the defendant proves that by a preponderance of the evidence, then the government doesn't have to prove beyond a reasonable doubt that he was not insane. I thought Powers is clear. The defense and the defense alone has the burden to prove by a preponderance of the evidence that he acted out of necessity. If he doesn't prove, it's more likely than not, imminence and on legal alternative, the other Griffin factors, then the trial court's obligated to find him not guilty.
Your Honor, I believe that is a fair and accurate reading of Powers. I think part of the confusion and the issue here is the dearth of case law on necessity, especially within this jurisdiction. This court in particular has never issued a published case finding necessity to even be a valid defense in this jurisdiction, let alone clearly rolling through what was the level necessary to establish it.
It may be that we don't have to reach the second or the ultimate question of who bears the ultimate burden, because if your understanding of the trial court's ruling here is right, that the trial court found that Mr. Evans hadn't even come forward with sufficient evidence to shift the burden, assuming the burden shifts, then that's kind of a separate, I mean, that's where the game is then. And that seems highly dubious to me, where generally, first of all, the trial court credited Mr. Evans' testimony. It also found certain things to be beyond dispute, which is his shoes were destroyed. I mean, one thing beyond dispute is that he stole the shoes. Everyone knows that. So all of that is out of play. So once, I mean, similar to self-defense, it's not that the defendant has to establish the, sort of legitimacy of their fear of being attacked. They just have to come forward with something. And Mr. Evans came forward here. It was credited that his feet felt like they were on fire. He tried X, Y, and Z. He couldn't do it. It was cold out. I don't think there's testimony evidence that he was aware of the donation bin, all kinds of things that I think would be at least enough to get past that first hurdle. Maybe not enough if he bears the ultimate burden, but it's enough to get past that first hurdle, I would think.
And Your Honor, I admit that I may have, because of the way the trial court specifically laid out its findings, it did sort of seem to implicitly instruct itself on necessity and then make its factual findings without necessarily determining, because the government didn't challenge or object to the necessity offense being argued throughout the trial at that point in time. And so ultimately, because Mr. Evans is challenging the sufficiency of the evidence in this case, the ultimate question before the court is whether, as a matter of law, no reasonable fact finder could have rejected that his theft was justified by necessity under the circumstances in this case. And I think that was where the trial court, in making its factual findings, that the harm was not sufficiently imminent as understood, as required by Griffin, and that there were other legal alternatives. Those facts were reasonably made, those determinative factual findings reasonably made, preclude that finding that no reasonable fact finder could have rejected that Mr. Evans' actions of stealing these shoes were justified by necessity.
Yeah, I'm not sure I understand that. I mean, if the trial court held, if we agree that Mr. Evans bore just an initial burden to come forward with some prima facie case of necessity, and we think that the trial court held him to too high a standard in establishing that, and that's why the trial court rejected the necessity defense, then that seems like an error of law that we would have to send it back for, right?
Apologies, Your Honor, just making sure I'm understanding the question you're phrasing. Your Honor, I think because the fact finder didn't, or the trial court did not find that as a matter of law, Mr. Evans had failed to establish the necessity offense. He simply found that Mr. Evans, based on these factual findings, had not established the necessity defense.
Well, it sounds like both sides in this case agree that the findings aren't necessarily clear on which stage of this the court was operating at. Isn't that reason enough on its own to send it back to get some clarity?
Your Honor, I think not. It is not, and that's because of the fact that the underlying, as the finder of fact, the trial judge was simply making factual findings as a jury or the trial court is required to do. And because there is no clear error with those factual findings, the trial court found that.
Don't you think there could be clear error? I mean, when I look at it, and I'm looking at the state of the shoes, which we've talked about some here already today, Mr. Evans has trench foot. It's really serious. That really affects the bottom of your feet. It affects the whole foot, but at least in his presentation, he's got bacterial infection, fungal infection, serious sores. It feels like he's walking on fire. This is affecting the bottom of his feet, and he went from having non-padded, busted up, potentially rubbing shoes, one of which may not have had a sole at all, to having nice, thickly cushioned slides that could fit his I won't say abnormally sized feet. I have large feet as well, but it's hard to find 15 or 16s. And I do not wear 15 or 16s. I don't want to imply that, but he found something that took away that pain. It sounds to me like the trial court could have gotten that wrong. There's at least one angle we could view that as clear error.
Well, Your Honor, first, I would push back on a couple things. The first is that Mr. Evans testified that the shoe that the slides that he obtained, his feet were still cold and still hurt, and that at the time that he was stopped by the loss prevention officer, that he was still hoping to go out and get new shoes to replace these shoes that he had just acquired. But even before then, is understanding, as the trial court found, that while he credited Mr. Evans' testimony that he was in pain, as Your Honor said, that as he testified, the level of pain that his feet felt, that
Well,
it's.
let me stop you there for 1 second. Is it kind of this ex post facto look where I'm looking at did the shoes actually resolve the problem? Or am I really looking at, did he believe they would, and was that a reasonable belief?
Your Honor, it is, I believe that there's both a subjective and an objective. It's the subjective of did the individual performing the illegal act reasonably believe that it was designed to remedy his harm? And then objectively, was that belief a reasonable one for him to hold? And I believe there was a single picture of the shoes that was submitted to this court, or at least of one shoe. And while it doesn't show the condition of the insole in that shoe, the outsole and the insole had begun to separate enough that the shoe was essentially a slide. The front of his toes were exposed, although it appears his heel was still covered. So the shoes essentially provided less covering for him, and only provided essentially an outsole. But the key thing here was with regards to the imminence of the harm, where the necessity defense is, by its definition, an extreme one. It is not saying that it's not attacking the mens rea. It is saying that we are explicitly justifying and excusing the breaching the literal terms of the law in order to avoid some greater harm. And specifically because it needs the harm from compliance must significantly exceed, as this court has noted, not just merely, not a 51 to 50%. It must significantly exceed the harm being there. And understanding, I think the Ninth Circuit in Powers described it as this imminence needs to be an emergency or a crisis involving immediate danger that is immediately dire, such that it resorts to this. And as the trial court noted, upon leaving PIW, Mr. Evans traveled on a bus for a period of time. He walked around at Columbia Heights, he panhandled, he went to several different stores asking if there was food that he could have because he hadn't acquired breakfast. And only after he wandered inside to the store at Columbia Heights where then he noticed there was a DSW did he proceed to look for the shoes. He didn't look for the shoes when he got out of PIW. He didn't look for shoes when he first arrived at Columbia Heights. He wasn't asking store owners for shoes. It was only after he had done this long series of actions that he finally stumbled in and saw the DSW that he then took that action. And that, as the trial court found, was not necessity. It didn't rise or it wasn't imminent. It didn't rise to the level of imminence, and it sort of counted against Mr. Evans.
So I'm confused, and I realize I'm starting to get very annoying here, but all of this goes to whether, under your framing, the government negated the necessity defense beyond a reasonable doubt. But I thought we had understood that the trial court implicitly ruled that Mr. Evans hadn't come forward with enough to even put necessity in play. And that's where the trial court was making its decision. And if that's the case, none of this other stuff really seems to be relevant to me. And the question is, did the trial court make factual findings that undercut Mr. Evans, the level of evidence that Mr. Evans had to come forward with to establish necessity as a potential defense? And when the trial court credited Mr. Evans' testimony and didn't find anything to the contrary, and we've got evidence that he felt like he was walking on fire, he had no reasonable alternatives, it was December, his shoe was destroyed, the trial court acknowledged that, then I don't see how we get to sort of this next step. It seems like legal error happened at that very point when the trial court credited Mr. Evans' testimony, but implicitly, in your view, found that it wasn't enough to shift the burden to the government. That seems like legal error to me right there.
Well, Your Honor, and I think it's because the trial court, again, seemed to, it wasn't that it refused to instruct itself or say that a necessity defense was even permitted to be made by Mr. Evans. It was that he seemed to self-instruct on the necessity defense. and then make the factual findings, essentially assuming without deciding that the necessity defense was in play. And by crediting Mr. Evans' testimony, that he had shown enough evidence to, if this were a jury trial, allow a necessity instruction to be given to the jury. It was then that he made the factual findings that there were other legal alternatives, that the action was not was reasonably designed to remedy the harm, and most importantly to the trial court, that there was not imminence in this harm such that the necessity defense was met.
Going that route, do you have a sense, and I know we've taken you over time, I only have one more question on my end after this, and any of my colleagues may have. Do you have a sense of the standard of proof that the trial court may have been applying if it assumed that the instruction should have been given? Was it looking at that, in your view, from a preponderance, or was it making its findings beyond a reasonable doubt?
I don't have a specific answer as to what like, the exact standard that the trial court was finding, but based on the words that the trial court utilized in its findings, it seemed very clear that this was not a close decision, despite the fact that he credited Mr. Evans' testimony. He acknowledged I think he, as a matter of fact, found that the shoes were damaged. But the fact that there were other legal alternatives, for example, that he was looking to go and acquire more shoes. Even then, the fact of him taking so many steps before seeming to then investigate the option of acquiring new shoes.
Understood. The last question I personally have is, do you also agree that duress is the closest parallel to this in the defenses that we've actually ruled on before?
Your Honor, I sort of take this in my answer in two parts. The first is because neither party briefed on duress. We acknowledge that. Based on the reading of the case law as we were looking into the necessity defense, the government's understanding is that duress and necessity are sort of, for lack of a better analogy, two sides of the same coin, where necessity is an environment, sort of act of God, environmental impact that forces an individual to take an action, whereas duress is another individual that essentially puts a gun to someone's head and forces them to break the law as a result of that. So Your Honor, that would be the closest sort of analogous based on the government's reading of the law.
So Mr. Brock, I'm not faulting you for any of this. We've got a situation with a combination of a dearth of case law, basically zero case law here, and a very cursory and cryptic ruling by the trial court, not to speak pejoratively in that way. So I understand the position you're in. It's just that we need some clarity here on what the trial court actually was doing. And I guess you don't have it, which makes sense, but that's why I've been asking these questions.
Yes, sir. Unless the court has any further questions, we would ask the court to affirm the trial court's ruling.
Thank you, Mr. Brock. Mr. Cohn?
Yes, I would like to embrace Judge Shanker's observation that it doesn't look, that what the trial court said here was in effect, I am not applying the necessity defense. The court was not, and the clearest evidence of that is that, as counsel for the government just noted, the ultimate question in a necessity defense is a balance of the harm to the defendant and the harm to society. And the trial court made no finding on that ultimate question. In fact, as we've been, I think, agreeing here, the only factor, and it's a factor, it's not the ultimate question that the trial court addressed, was imminence. And as it happens, it got that clearly wrong. And it didn't address the other important factors that counsel for the government was talking about. Were there available legal options? Was his conduct reasonably attempting to deal with his harm? So we have a trial court here that, in effect, as in other cases which involve juries, did not instruct on the on the necessity defense, did not make did not address the factors and make the findings that are necessary to reject a necessity defense. And I'd also like to embrace Judge Epstein's observation about the difficulty of having a preponderance of the evidence burden in a reasonable doubt context. This court,
It's not difficult, it's inconceivable to me.
right,
Yeah.
and it's not just to you, I believe it's the Lillican case, and I can get you the exact site after our argument, but this court has reversed convictions where the trial court incorrectly instructed the jury that as to a defense, it had to find that proof that the defendant proved his defense beyond a reasonable doubt. This court held that that unconstitutionally shifted the burden of proof. That
You're saying a defendant having to prove a defense beyond a reasonable doubt, correct?
right, that's what that case says.
But it isn't the standard that we would potentially be looking at, especially if we were adopting powers or some of the federal case law, that if this, as it's been alluded to by colleagues in questioning, if it's a preponderance of the evidence, if this does not affect an element of the actual case, then it's a pure affirmative defense and the defense must prove it by preponderance of the evidence. However, if it does affect an element of the case, then the sufficient evidence has to be brought, and then it's the government's duty, not the defense's, to disprove beyond a reasonable doubt.
I understand, but what I understood Judge Epstein, it's all clear, but what I understood Judge Epstein to be saying is that once you shift a defense, the burden to the defendant to prove something beyond a reasonable doubt, and once one beyond a preponderance of the evidence, and once one acknowledges that the defendant has met that burden, has established the defense by preponderance of the evidence, it becomes very hard, some would say, impossible to conceive how the government could now disprove beyond a reasonable doubt facts that have been established by a preponderance of the evidence. So to go down that road, even though the Powers case does it and other cases do it, is skirting, and it's difficult to balance with due process. Courts have done it, and there is case law on this. So, but I do want to credit Judge Epstein for noting the difficulty.
Judge Epstein's point is well taken. And wouldn't you say that, I mean, it doesn't sound like it's that difficult of a parse, right? Like if a defendant manages to prove something by a preponderance of evidence, then just definitionally, they're going to win that defense, right?
Well, no, I think the cases say then it becomes the government's, the burden shifts back to the government.
Well, I mean, I think Judge Howard's prior question was maybe that there's an argument that only applies to affirmative defenses that negate an element of the offense. And so if we have a class of affirmative defenses that don't negate an element of the offense, like necessity and duress, well, let's just stick with necessity, then there's nothing constitutionally suspect in placing the entire burden on the defendant. And so how that actually plays out, I'm not sure. The defendant has to prove the affirmative defense by a preponderance, and that's it. I mean, this was Judge Howard's question. Or can there be something more than a preponderance? It's probably right that it'd be a little weird to require the defendant to prove an affirmative defense beyond a reasonable doubt. I don't think we've ever used that, but I'm not sure. But I mean, I guess my question then, to actually have a question, is there anything that you think would be inherently wrong with having a framework where with necessity, the defendant bears the entire burden, whatever that level is, whatever the standard is, and that it doesn't shift to the government?
The defendant bears the burden of presenting some evidence. I think government counsel said that, so I would stay with that. Enough evidence that the jury would be in a jury case have to be instructed on the defense. I would really find it regrettable for this case to be the case that decided that this issue of preponderance versus not preponderance, because it hasn't been briefed, and it's a difficult question. And it's an important question that has, constitutional implications. Some, I should bring to the court's attention in case it doesn't know. Some courts have said the legislature must speak on this issue before, it's not up to the courts. Only if the legislature, as in say the insanity defense, only if the legislature has spoken and said, you defendant bear the burden of proving, say, insanity by XYZ proof. But we're not going to get into the business of burden, of deciding who bears the burden. Fortunately, from my standpoint, respectfully, as we've been discussing, the trial court's findings here have such clear error and such failure to address the defense that we don't need to get into the
Well, the problem there is if we agree with you, we have to send it back. And then what are we telling the trial court to do on the second time around?
well, my preference would be find that once you, as you did, credit the defendant, find whether the evidence beyond a reasonable doubt nonetheless establishes that he committed this crime. So that would be what the trial court would have to find. And I have a feeling this case wouldn't come back because there is reasonable doubt, and my client would be acquitted.
Any further questions? All right. Thank you, counsel. Thank you both for your arguments today. The case is submitted. We'll ask the parties in Simmons et al. V. Jackson to come to council tables. Please proceed.
Good morning, Your Honors. My name is Eden Brown Gaines, and I'm representing DARRY Simmons and PCMD LLC. I'd like to reserve 4 minutes for rebuttal. With the court's permission, I'm going to dispense with a reiteration of the facts in this case and discuss them as they're relevant to the issues to be presented to the court. Okay. Procedurally, this appeal is focused on the judge's decision on the defendant's renewed motion to dismiss. There's some overarching issues that we've raised that apply to the judge's decision with respect to the breach of contract claim, and then ultimately the decision with respect to the consumer protection law.
You argue that the trial court committed error by failing to interpret the contract. What provision of the contract did the trial court fail to interpret?
The provision that speaks to the work being completed in a workmanlike manner. The meeting.
At any point in the trial, did Ms. Jackson take the? I mean, I understand. What was the ambiguity? Did Ms. Jackson ever take a position inconsistent with your interpretation of that provision?
In essence, yes. Ms. Jackson's position was that the work had been completed and it had not been completed correctly.
As I understand it, her position was that she fired your clients, in late January, early February, because they hadn't done a good job and problems needed to be corrected that the contractor wasn't willing to correct, and she needed to bring new people in.
Now, there was a lot of testimony and argument from Ms. Jackson's side that the work was nearly complete, and that argument came to evidence the fact that the work had not been completed in a substantial workmanlike manner. The defendant's position was the court failed to interpret what that provision, the exact words is all work to be completed in a substantial workmanlike manner, according to the specifications submitted per standard practices.
So the trial court instructed the jury on how to interpret a contract. It was the standard instruction. Did you object to that instruction?
The trial court did not actually tell the jury exactly how to interpret completed in a substantial workmanlike manner. The trial
No,
courts.
but it gave general instructions about, normally if a provision of a contract is ambiguous, it's for the jury to interpret it. The judge can construe it as a matter of law. And the instructions included the standard instruction about what evidence you look to decide what an ambiguous provision meant.
Well, there was no argument that the contract language was ambiguous, and I think that's a mistake also that the defendant, the appellees asserted in their brief. The defendants and appellant did not argue that the contract was ambiguous. Instead, they argued that it was the responsibility of the trial court to interpret the language of the contract.
But if,
And that-
so the procedurally, the way that would have worked is the trial court would have, well, let's back up. I guess your client would have had to have moved for summary judgment
That's
on,
correct.
and you didn't do that, right? Your client didn't do that
No, we absolutely moved for summary judgment, in
On the-
fact, on 2 occasions.
on the meaning of, on
Yes.
that specific question?
That's correct.
Where in which motion was it, and exactly where in
There-
the motion did you?
There were 2 motions for summary
Right.
judgment. Both motions addressed the issue that there were no disputed facts and that the interpretation of the contract was in the court's province, and the way to interpret the contract was on the term substantial workmanlike manner. Now, obviously, denial of summary judgment isn't something that's appealable, but our brief does outline the summary judgment motion and what was argued in the motion precisely for that point, to show the court that it had been raised below.
And
Okay,
where
so-
did the judge adopt an interpretation of that provision? I mean,
The judge, I'm sorry.
that was wrong.
The judge stated that it was for the jury to determine what complete meant. The judge stated that with respect to the decision on summary judgment, and I believe at other times with respect to the pretrial proceedings, because the appellant continued to raise the point that it was the judge's responsibility to interpret that provision of the.
So then, if I was wrong about the summary judgment motion, I apologize. But
Okay.
then I guess the second step of the procedural way this would work would be your client would have had to have asked the trial court to instruct the jury on the meaning of complete in this context.
Well,
And that jury instruction was never requested,
the
right?
judge had said at that point at several times that she believed that it was the jury's province or responsibility to determine what complete in a substantial workmanlike manner meant. Where the appellant objected was through the summary judgment proceedings, through the pretrial proceedings, and then in their motion for judgment after the close of the plaintiff's case, as well as the renewed motion at the end.
But just so I'm clear, there was not, like in the instructions conference or in proposed jury instructions, I'm not sure if those were filed, I'm sorry, but there was not a specific request, detailed specific request, explicit, that the trial court should instruct the jury that it has determined as a matter of law that complete in this contract means X, and that the jury has to adopt that definition?
No, there was no request exactly as you have framed it, that the judge has to interpret this or that it means X. The judge used basically the standard instructions with respect to that. We did object, indicating it several times, as I mentioned, that the proper thing for the judge to do was to interpret the contract.
But
And
did
we-
you object to the jury instructions?
We didn't object to the jury instructions themselves or the absence, is I think what you're asking, of
Yeah.
that specific instruction. No, there was no objection to the absence of that instruction. And there was discussion about it, at which point at the pretrial and at other times, the trial court made clear that she believed it was for the jury or within the jury's province to determine what completion meant under the law. We argued at several junctures, as the court knows, I'm focused on the renewed motion for a judgment as a matter of, as renewed motion for judgment or notwithstanding the verdict, that again, we argued that it was for the judge to interpret the meaning of the contract language that the.
If the judge left it to the jury, did Mr. Simmons testify about what the meaning of complete is?
Yes, he did.
And did Ms. Jackson or any of the experts say, no, that's not right, complete means something different?
There was significant testimony about whether the work in fact was completed. There was.
No, well, there was significant dispute about whether the work was completed in a substantial workmanlike manner. But where did, I'm not trying to pronounce the name of the lead lawyer at the trial. Where did she argue in her closing that the work was complete?
There were several instances where there was argument that they brought out that Mr. Simmons testified that at the point that he indicated that they were going to put up drywall, that maybe the work was 85% complete. They
And the
argued
argument,
that,
and the
it-
plaintiff's argument was that that was misleading. That it was,
well,
the work wasn't complete and that there were significant problems that were covered up by the drywall and that Mr. Simmons was unwilling to go back and fix them.
That
So
was-
they fired him before the work was
that's
complete.
a separate issue. And we can talk about that under the CPPA. But with respect to the testimony that came in, it was Mr. Simmons' position that the work wasn't close to complete. When you ask the question about where was that testimony, there was significant testimony. For example, the inspection card from DCRA came
but-
in, and there was testimony that indicated that half of the inspections that were to occur had not been done or called
Right, there
for
was, there
yet.
was a partial inspection and there was all kinds of, there was a dispute about whether the work was in fact complete, but where was there a dispute about what the word complete meant in the contract?
At the motion for summary judgment, at the renewed motion, at the motion for judgment as a matter of law, at each point and each juncture, the appellants constantly argued that it was the court's job to interpret the word complete, that the usage in trade or the industry standard for what complete meant under the contract in a construction format was significant. Not that it needed to be ambiguous in order to apply usage and custom, but that in interpreting the contract, the court should have used usage and custom to determine whether or not the work was actually
So help
complete.
me, I'm getting confused as we go along. As I read the record, there was a lot of statement that the contract did not have ambiguity. How does that square with this?
The appellant isn't raising an issue of ambiguity. I think that the plaintiff or the appellees believed that our argument that usage and trade or the industry standard, that the judge needed to apply that in interpreting the language could only occur if the contract was ambiguous. The appellant actually did not make that argument because it's not accurate. Usage and trade or the industry standard helps the judge in understanding in a construction context what the meaning of that is. It doesn't mean that that language is ambiguous. It just simply means that the court could adopt that industry standard and basically determining what it means to be complete. And in so doing, the court needed to understand the process of construction. That work isn't substantially complete when there are 4 and 5 inspections that still need to occur. That work isn't substantially complete when a party asks for changes, which are allowable.
So how does that complete affect the workmanlike quality?
Because of the way construction, the sequence of construction, there was testimony about that and how construction ultimately works. There was testimony that PCMD and Mr. Simmons had not had the opportunity before being terminated to even come and do their own inspection, to call for inspections at the various stages of the job. So the work wasn't close to being complete in the terms of the meaning in the industry because he, for example, had not called for a second rough-in inspection when he was following the changes that Ms. Jackson wanted to make. He had
Okay,
not
I'm sorry
called.
to interrupt, but you're getting low on time and I wanted to address 2 other issues about the counterclaim and joint and several liability. Do you dispute that PCMD's breach of contract counterclaim was compulsory?
No,
Why didn't PCMD seek leave to file a counterclaim since it didn't file it within whatever it is, 14 or 20 days after its initial motion to dismiss was denied?
well, the curious thing about that is that after PCMD's counsel filed the initial motion to dismiss, typically you would file your answer within 15 days after the ruling on the motion to dismiss, and that did not occur. The parties went on to discovery. It seemed that no one,
So my question was, so why didn't
well,
previous counsel file a
I
counterclaim?
can't answer that because I wasn't previous counsel. I don't know. But
And
what,
then why didn't you file a motion for leave to file a counterclaim since the counterclaim should have been filed months, if not years earlier?
well, the reason I didn't file it is because they had amended the complaint, which would have required an answer with respect to the amended complaint. And since it was the first answer that was in the case, I just filed the counterclaim with the first and initial answer. So the court's reasons for denying the counterclaim were because of the delay that it would cause the case, which I think is belied by the fact that the court had reopened discovery in any event.
Well,
with-
that period of discovery had closed, but by the time the trial court ruled on the motion, but what did
Well,
did the defendant ever explain what its damages it claimed under its counterclaim? Did it ever quantify the damages?
did the defendant quantify the damages?
Quantify the damages,
I don't believe so. I think the defendant just asserted the counterclaim of breach of contract.
right? But then there'd be damages associated with that, correct?
Right, but we never got that far because the court struck the counterclaim and didn't allow it. There's no requirement that the defendant exactly state their damages with respect to
But
asserting.
that's, I'm asking if otherwise the defendant do you agree that the measure of damages for the counterclaim would be lost profits?
Yes.
Okay.
Counsel, do you agree that the counterclaim was not related to or prompted by the amended complaint? Rather, it was a counterclaim that existed in theory based on the original complaint?
Certainly, the answer should have been filed at the right time and the counterclaim should have been asserted there. The standard of review is abuse of discretion. Our argument is that the court abused its discretion based on its reasons for determining that the counterclaim would be stricken. One of the reasons is because the court believed it was going to unreasonably delay the case, and that was arbitrary and capricious given the fact that the court was already reopening discovery with respect to that issue. Additionally, the issues about her terminating the contract before they had the chance to finish it had already been a part of the existing discovery period. It had already been something that was covered. The counterclaim just hadn't been established. And so it was arbitrary in that sense because the parties had really covered that issue already as a part of the case. It was kind of a defense to Ms. Jackson's breach of contract claim. So it was just reiterating that defense in another fashion. With
Okay,
respect to the CP.
Oh, I was going to go with respect to joint and several liability. Do you agree that corporate officers are personally liable under the CPPA for any misrepresentation?
Yes, the statute has provisions where you can find for the corporation and separately for individuals to include corporate officers.
Okay,
So
and was there any evidence that anybody other than Mr. Simmons made any of the alleged misrepresentation?
there was no other evidence with respect to that, but the point with respect to the statute just simply is that it already creates a provision to ascribe liability to separate parties. So the joint and several liability casework is based on torts and a different type of action that's outside of the rubric of a statute that already has provisions for treating parties differently.
So your argument is not so much that joint and several liability was precluded once the special verdict form broke out the damages. It's just, it's more general that the CPPA does not provide for joint and several liability in the first place.
It's silent to it because the function of the CPA makes it clear. So what the court did in the special verdict form made sense because it was consistent with the way the CPPA is structured, meaning that the law allows for liability to be ascribed to the corporation and the law allows liability to be separately ascribed to an individual. So when the court did the special verdict form following that rubric, do you find against the corporation and do you find against this individual and how much separately, that was consistent with the statute. To make a finding ultimately that you could cross it and make the individual, when there was a separate finding by the jury as to what the individual would owe and say it's jointly and severally with the corporation is inconsistent with the function of the statute.
All right, if there's no further questions. We'll save your time for rebuttal.
Thank you.
Mr. McMullen?
Good morning, Your Honors, and may it please the court. Defendants fail to cite any evidence of the record or case law that warrant disturbing the jury's verdict below. They raise a number of objections, but as we can discuss with respect to each of those objections, none of them stand up to the overwhelming evidence that defendants breached their contract with Ms. Jackson and defrauded her by doing dangerously inadequate work on her home and covering it up. As we now can discuss, the court exercised her discretion properly and applied clear legal principles and entering judgment with Ms. Jackson consistent with the jury's verdict. As we'll now discuss, defendants' arguments on appeal fail to address those clear legal principles. So I wanted to start with the ambiguity argument. First, we'd like to note that defendants did not ask for instruction on the contract interpretation. And not only are they raising their ambiguity argument for the first time on appeal, which in and of itself is improper, but they explicitly argued against ambiguity and benefited from that argument below.
Well, at one point, and I'm not sure how to pronounce S-Z-A-N-Y.
Miss Zaney,
Pardon?
Miss Zaney, like
Zaney, okay. I apologize. So Ms. Zaney, there was a conversation about the jury instructions. And Ms. Zaney said, this is on pages 1104 to 1105 of the joint appendix. I would like to be able to cross-examine defendants on the point about the drafting of the contract. I do think we can offer proof of what we would argue is the ambiguity if we were allowed to have that instruction. What was she talking about?
so that comes down to the disagreement between the parties over the meaning of the contract provision requiring that the work be completed that all work be completed in a substantial and workmanlike manner. We feel that the reasonable interpretation of that any reasonable juror would also agree with, as they did in this case, is that any work that is going to be done has to be done properly. Whereas defendants take the position that it means that you can't evaluate the work until the defendant says, no, we're done, everything's done. Here's like turning over the keys. Everything's been done. And you can't fault us for up until that point, because in theory, anything can be fixed until we say, no, we're done. And so that's what the distinction was.
But so are you acknowledging then that there was an ambiguity?
Well,
mean,
our
you're-
argument was our position is that it's not ambiguous. Just because parties disagree over the actual interpretation doesn't in itself make it ambiguous. But to the extent it's ambiguous, the jury should have known that ambiguous contract terms are to be construed against the drafter.
Well, you didn't ask? Well,
We did ask for that in jury instruction, and the defendants objected to it and said there is no ambiguity, and the court agreed and struck our proposed jury instruction on construing against the drafter.
So I may be taking you out into left field, but I'm a little bit confused about all the debate about ambiguity. As you may have known when you researched all of us, when you found out who the panel was going to be, I used to be an ALJ at OAH, and I did cases that would now be from the Department of Buildings. It seems to me like you couldn't contract for something substandard, something below the regulatory requirements of the city, and that workmanlike standard is a regular feature of our regulatory regime around construction that DOB and DCRA long before it was always doing. And so there has to be a base level minimum, right? Is it your position that the contract did anything more than just adopt the city's regular standard?
I mean,
And I acknowledge this was not the focus that the parties appear to have had. Seems like it would have made things easier if it was at one point.
well, I agree that that when our client signed the contract, she was saying the work had to be at least a minimum level of quality, and she testified that what she understood that to mean. She testified that she understood that to mean the work would be of good quality, that the craftsmanship would be great, and that it would be up to code.
So,
did she,
go ahead.
if you summarize the party's position accurately, my initial reaction was that you were both wrong. I mean, obviously, work can be judged on an interim basis. There can be partial inspections. DCRA can say, the electrical work there's a problem. It seems that there's no provision in the contract such as it is. It was just the proposal that Ms. Jackson accepted about cure. But I mean, did Ms. Jackson dispute that she had to give the contractor at least some opportunity to fix if DCRA identified some problem, and the contractor might say, oh yeah, I'll take care of that?
We would not dispute that, and there is testimony and evidence of record that Ms. Jackson gave the contractor multiple opportunities to fix the problems after she became aware of them. And in each case, she found that the proposed fixes were inadequate. And this is further bolstered by the fact that the replacement contractor, after she found one, because she testified that she had a hard time finding replacement contractors because they came in and looked at the quality of work and said, I don't want to have anything to do with that. The one that, and eventually redid it, had to tear down the work and basically start over. And even then, all he left was the foundation. And even that he wanted to redo because he found significant problems there that resulted in leaking. But because of the enormous expense of tearing out a foundation and redoing the foundation, our client couldn't afford that. But she testified she gave multiple opportunities to redo.
So what evidence was offered at trial that would permit a reasonable jury to conclude that Mr. Simmons was not planning to correct the code violations and other problems that Ms. Jackson presented evidence about?
Well, first of all, the fact that they drywalled over everything, they spackled it, they sanded it, they painted it, they put down flooring, they put in the counter, the cabinets, fixtures. It's just not credible to say, well, I was going to come back and remove all that stuff and fix the problems underneath. That should be pointed out, never would have been found, but for Ms. Jackson's diligence. Once she started to notice a problem with the HVAC system and bringing in professionals first through somebody she knew and then through recommendations, and they started taking things down, and then she got the recommendation to remove the drywall. And this is where she finally understood the significance of the problem and was advised by two people who testified at trial that they would not let Mr. Simmons' company touch this project any further and put her more in the hole.
Can we ask you about the joint and several liability? At least that's where I was going to go next.
So was I.
Okay. So your colleague on the other side says that this is an issue of CPPA interpretation. Would you agree that we haven't decided whether the CPPA, and the statute is silent, and we haven't decided whether CPPA allows for joint and several liability?
I don't believe I've seen a case on this court, but I have seen multiple cases in applying DC law. So for example, two of the ones we cited in our brief, the Faison case and the McMullen case, no relation, was that the Faison case said that when multiple defendants are found to have caused a single injury, that joint and several liability must be applied against those defendants for any compensatory damages. And then similarly, the McMullen case, that was a CPPA claim, and the damages were awarded jointly and severally against the defendant in that case, against the individual defendant as well as the company he owned.
Why did you agree to a special verdict form that had separate damage calculations on the CPPA claim for the company defendant and the individual defendant when your position was Mr. Simmons was liable under the CPPA because he was the principal and made all the misrepresentations?
Well, Your Honor, in hindsight, that was probably a mistake, but the jury still found that Mr. Simmons was individually liable.
What, do you have an explanation about why the jury awarded much less in damages against Mr. Simmons than against PCMD, even though he made all the misrepresentations?
I can't speculate on why they did it, but the case law is clear in situations like this that the court is to omit any the breakout and apply award damages against all defendants for the largest amount awarded against any defendant. And that's really the only outcome that makes sense under the law of joint and several liability. So I guess that's.
You've answered my question.
Thank you, Your Honors.
Just a few quick points, Your Honor. I just want to make clear that the appellant is not arguing and never has argued ambiguity. That issue surrounds the concept of custom and usage, and it just needs to be clear that the contract doesn't need to be ambiguous for the court to apply custom and usage or trade understanding to the language of a contract in attempting to interpret it. The second point is that notwithstanding the jury instructions, I just wanted to be clear that the objections came with respect to the renewed judgment, the renewed motion for judgment. There, again, the appellant objected to the court's failure to interpret the contract and to determine what the meaning of completed was to be, and then apply the facts, that it was the jury's province to determine facts and not interpret the contract. The issues with respect to what happened, it would be similar to if my client paid me to prosecute this appeal. I wrote 10 words in an appeal brief and then I'm terminated, which he would have the right to do. But then he couldn't sue me for not seeing the appeal to conclusion or any mistakes that may have happened when I didn't have the opportunity to do it. And that's why the court's interpretation of completion in this case was so important.
But you agreed to an instruction that a material breach entitled Ms. Jackson to terminate the contract.
I did, but that doesn't have anything to do with how the court interprets completion or the fact that we objected ad nauseum to the fact that the court wasn't interpreting the contract language and determining what completion
So
meant.
is it your position then that that provision of the contract, if your position is that that provision of the contract meant that Ms. Jackson did not have the right to terminate for a material breach, then you should have objected to the instruction.
She would have had the right to terminate for a material breach, but there was none. So you can give an instruction as to whether you found a material breach, blah, 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 but there actually was no material breach in the contract because the work had not been completed. The term of the contract that was sentinel was the fact that the work had been completed. And if the court had looked to usage and trade, the custom and usage and trade, it would have been clear that there was testimony from both sides about the sequence of instruction. There was testimony from both sides about the inspection process. There was testimony from both sides acknowledging that this contractor hadn't gotten through the majority of the inspection process.
But is your view then that if that instruction, if the trial court had interpreted the contract in the way you wanted the trial court to and had instructed the jury in that way, that would have mandated a verdict in your client's favor at that point? Or do you think there would have been still questions for the jury as to whether even under your view of custom and usage about the meaning of completion, there still would have been factual questions about whether the work had been completed under that interpretation? And the follow-up to that question is then, could the failure of the trial court to instruct the jury in the way that you wanted it to be harmless error? And third part of the question is, under these facts, how could it not be harmless error when the contractor closed everything up, drywalled everything, painted, and there's no conceivable way in which anyone could possibly think that the contractor planned to rip all of that down and fix electrical and plumbing problems behind the walls?
Okay, you're gonna have to help me because it's the third question.
Understand.
Okay, the first question is in the appellant's view, it never should have reached a jury trial because there aren't significant or material facts that were in dispute. The judge's responsibility was to interpret the language of the contract, and had the judge done that and then looked to the material facts, the judge could have determined the true judgment in this case without it going to a jury trial. That was the point of moving for summary judgment. You don't appeal that, but that was the point of the renewed motion for judgment notwithstanding the verdict, and initially the motion for judgment after the plaintiff's case in chief. So our opinion is that it didn't even need to reach the jury. Juries, who can predict what ultimately they'll do, but in this case for reversal, it never should have gone there. For reversal, you could have looked at the judgment, the request for judgment as a matter of law based on the case in chief with the judge properly interpreting the contract. It would have never gone to the jury. Or you could have looked at the renewed the renewed motion for judgment notwithstanding the verdict for the purposes of reversal. You never need to get to the jury instructions and what happens with the jury.
You agreed to a jury instruction that said you can find that if you find by a preponderance of the evidence that Ms. Jackson prevented PCMD from completing the contract, they're excused from performance. So
Yeah.
that was the instruction that you agreed to.
And that is an accurate instruction, because if prevention is a
Okay, then-
doctrine
And
that,
then it was up to the jury to decide whether your client had proved by a preponderance of the evidence that Ms. Jackson prevented her. And Ms. Jackson said, no, I didn't prevent him. In fact, I gave him plenty of opportunities to fix the problem, and he just wanted to get paid and kept saying, I'm done. I'm almost done.
but the
Give me the rest of my
substantial
money.
evidence was different than that, right? The evidence was that he hadn't called for many of the inspections that he would have needed to call for in order to get to the work being complete. The evidence is that the trades were working. He, as the GC, hadn't even had the opportunity to come on the project and supervise it himself. The evidence from all parties, the people who testified and said that there were code violations, acknowledged that they thought the work was complete. They didn't know when they were looking at the work that she had terminated him. They didn't know when they were looking at the work that the work wasn't complete. They all agreed to the sequence of construction. They all agreed to the fact that inspections had to happen. So there was plenty of evidence that was clear that the work had not been completed and that she terminated him and had prevented him from getting to that point at trial. To answer, I might have forgotten the second question, but when you spoke to the walls being closed up, that actually wasn't the evidence at trial. There was plenty of evidence that he did drywall some walls. There was evidence that others had not been finished. There was evidence that there were parts of the house that had been finished and that there was no dispute as to whether those things had been done completely. So the fact of drywalling wasn't evidence of completion. Everything wasn't done spackled. There was plenty of testimony that they were still trying to decide where the HVAC unit should be, and that was going to affect the plumbing and the ductwork for the plumbing. So there was lots of evidence with respect to the drywalling, not meaning it to be complete. But then there was also testimony from both sides that when you go to the subsequent stages of inspection, even if you're wrong, say you put drywall up, the inspector's like, you shouldn't have done that, the contractor has to take it down now at their own expense, or it could affect the schedule of contracting, and then maybe you could sue for not getting things done in time. But this is an industry part of the process. Even the subsequent contractor that she hired acknowledged that he failed inspections and had to go back and do work. And everyone testified that that is a natural part of the construction process. So it's difficult for the layperson to hear that, because when someone's working on your house, you want everything to be perfect. But the evidence is that's not the industry standard, and that's not actually how contracting works. And I'm sorry, Your Honor, I forgot the second question.
No, they were all tied up together, and I think you touched on all of them. Thank you.
Okay. So I also, oh, I'm sorry, I'm out of time. This-
Any further questions?
Okay.
Thank you.
Thank you.
We don't do sir rebuttals normally. Thank you. All right, the case is submitted. Thank you parties for your argument. We will now hear argument in number 24 CO 548, Johnson v. United States.
Thank you, Your Honor. Lee Gamus on behalf of Appellant Bobby Johnson. I'd like to set aside 2 minutes for rebuttal. Although Mr. Johnson had previously been convicted of 2 prior felonies not committed on the same occasion, he did not fall within the ambit of 22-1804A because he had not been convicted of those felonies twice before on separate occasions. No. In conducting a statutory construction, this court must look to the law's structure, the law's plain language.
So, counsel, how are we reaching to the merits of this statutory interpretation question in the first place? We have 2 separate reasons to conclude that Mr. Johnson was not sentenced under 1804A, the statutory enhancement. One is we said so previously. And number 2, he was not sentenced above the statutory maximum.
Correct. So those are the questions. I'm not saying that they're correct. Johnson 2, the law of the case problem, doesn't law of the case issue doesn't answer the question before this court. That pertained to the applicability of 23-111, the notice provision, which admittedly only applies when the sentence allowed goes over the statutory maximum. That doesn't speak to whether the judge at sentencing, Judge Crowell at resentencing, correctly applied 1804A. That's a separate question that wasn't at issue.
Well, but it's, I mean, he couldn't have correctly or incorrectly applied 1804A if he wasn't applying 1804A at all, which is what we said in Johnson too.
This
I
court
know,
did-
I know in Johnson too, we weren't talking about Judge Crowell's resentencing, obviously, but we were talking about the sentencing and I mean,
It was
ipso
assumed-
facto, the resentencing couldn't be under 1804A if the original sentencing wasn't under 1804A.
I mean, the original sentencing was under 1804A. It was not an instance implicating 23-111 where that took us over the statutory max already allowed for ag assault while armed.
23-111 is the procedures that must be implemented or followed by the government in when 1804 is at issue. Or another statutory enhancement sentence. I mean.
I disagree. I mean, 23-111 applies when the potential sentence goes above under the substantive offense, ag assault in this case.
But it didn't here, right?
Right, but that doesn't mean 1804A didn't apply, and Judge Crowell applied it at the resentencing. 1804A says you can impose such greater sentence as deemed necessary up to 30 years. It doesn't say 1804A doesn't apply, only applies when you go above the 30 years or when you can go above the 30 years. And that's not how Judge Crowell treated it at the resentencing.
Well,
here.
he was applying the concepts of 1804 under the voluntary sentencing guidelines, which is allowed for under the voluntary sentencing guidelines in Appendix H, but
Right.
is
I
not
mean,
a statutory enhancement.
well, it is. I mean, that gets more to the cognizability issue. The government here is trying to say this isn't a statutory interpretation issue. This is simply a guidelines question. But 1804A is a statutory question that has guidelines implications, admittedly, but it's still.
I'm looking at the MOJ in Johnson too, and there's a paragraph that talks about the sentencing guidelines and says, even if the judge relied, that his decision about what sentence to impose with respect to the guidelines was affected by a misunderstanding of whether the sentencing enhancement applies, doesn't matter. It's not reviewable.
Doesn't
They're
matter.
they're the alleged statutory violation involved the procedural requirements rather than the substantive requirements, but doesn't the same reasoning apply when we're talking about whatever it's 1804A rather than.
No, I mean, 23-111 doesn't, as this paragraph says, and paragraph from the MJOA, doesn't affect a discretionary call when the maximum is still within the statutory limits. That's what 23-111 is about. It's about notice ahead of time so you know what your maximum punishment is, and fairness and not increasing that after you take a plea or after a trial starts. Doesn't tell us whether 1804A applied at the resentencing as a statutory matter.
Okay, but then how did it apply? Fine, take Johnson 2 out of the picture for a
Right,
moment.
okay.
How on earth does 1804A, how can a defendant get a statutorily enhanced sentence if the sentence does not exceed the maximum sentence that is independently authorized by the substantive statute?
I mean, so that's, I mean, the question is, I think implicit in that is, does 1804A apply when a defendant isn't exposed to a punishment above the statutory max? That wasn't litigated below. The government urged Judge Crowell to apply it at resentencing. Judge Crowell, after doing this whole statutory interpretation, asking for additional briefing, it's in his order. We didn't challenge it on that basis.
But
It seems to
that's
be a
not my,
point that was assumed that 1804A applies. I mean, because it allows for a greater sentence. It's a legislative determination that recidivists that fall under the statute, there's a thumb on the scale to punishing them more. The fact that that has guidelines implications doesn't, as the government would have it, transmute that statutory question into a guidelines question. Now, maybe in this court's opinion, maybe it's prudent to say, assuming without deciding that 22-1804 applies, even when you don't go above the statutory maximum, as opposed to a thumb on the scale, to give a greater sentence when someone falls within this recidivism provision, maybe it would be prudent to write the opinion in that way. But it wasn't litigated below, and it's certainly not, we haven't crossed swords with that on appeal. So I think that's sort of 22-1804 is a statutory question, and the fact that it has guidelines implications doesn't transform it.
okay, so then you seem to be acknowledging it's a statutory question, and then here you're raising a guidelines question.
We are not raising a guidelines question. It's a statutory interpretation question that has guidelines implications. The government has tried to transmute this into a guidelines question. We mentioned the guidelines exactly once in our opening brief.
Okay, but you would agree that Judge Crowell could have sentenced Mr. Johnson, could have never mentioned 1804A at all. No one could have discussed it, and he could have sentenced Mr. Johnson to the exact same sentence that he imposed.
Yes, and
Right.
that, I mean.
And you would not be here. We would not be here.
No. I mean, and that falls back on the line of cases that this court doesn't review for excessiveness or proportionality, or
So then how is this
reasonableness.
not a guidelines question, right, as opposed to a statutory question?
I mean, if you look at the cases that the government relies on, the cases that say we don't review guidelines questions like Speaks and RW pertain to guidelines provisions. In Speaks, what was at issue was guidelines chapter 7, which has a bunch of rules when you go concurrent, when you go consecutive. This court says that's a guidelines question. We're not resolving that. In RW, it was a provision that allows for an increase in the instance of a vulnerable victim. RW said the complainant was not a vulnerable victim. This court says we're not addressing that. That's a guidelines question. And underpinning that, the reason those cases came out that way is DC Code 3-105, which is part of the enabling statute that created the guidelines in the first instance, which says that the guidelines don't create any legally enforceable rules, but they don't diminish any rules that currently exist. I'm sorry, any rights that currently exist. Don't create any enforceable rights, but they don't diminish any ones that currently exist.
So what?
We've always had a right, a defendant had a right not to have a statute applied to him when that statute properly constructed doesn't apply to him. And that's what's going on in this case. And it's cognizable under, so it's not a guidelines thing, Speaks in RW, which involved, we're not going to review guidelines interpretations. There's a statutory interpretation, which this court reviews all day, every day. And it's cognizable, as we said in our briefs, under either a due process rubric or a simple abuse of discretion rubric. Right? We know from Johnson that a judge necessarily abuses its discretion when it misapplies a principle of law. And this court has applied abuse of discretion in sentencing contexts, like in Houston. And we also have a due process rubric when there's a defect in the again, we don't review for reasonableness, excessiveness, proportionality, but when there's a defect in the sentencing process itself, then that affects due process, and this court will review. And again, the defect in the sentencing process itself here was Judge Crowell's misinterpretation of 1804A.
So let me go back to Johnson too. Suppose Judge Rankin had said, you know, he said he ordinarily follows the guidelines, said, I intend to follow the guidelines here. The guideline range here is higher than the pre-sentence report indicated because of the enhancement. And he rejected the argument that the enhancement didn't apply because of a lack of compliance with 23-111.
Mhm.
Would the result in Johnson have been any different?
I'm sorry, could you?
Well, what I'm asking, basically what I'm asking is if Judge Rankin had made
At the first
explicit.
sentence? At the initial sentencing, you're asking?
Yeah,
Okay,
yeah.
I'm
But
sorry.
instead, I mean, as I understand Johnson too, the Court of Appeals inferred, I said, well, actually said that Mr. Johnson had implied that Judge Rankin increased the guidelines range because he thought the sentencing enhancement applied. He shouldn't have done that because there was a violation of 23-111. If Judge Rankin had been explicit about it, would the result in Johnson 2 have been any different?
Explicit in saying 22-1804A doesn't apply? I'm not applying it?
Instead of saying the sentencing enhancement applies because the government complied with 23-111, that even though it mislabeled the conviction for assault with significant bodily injury as, you know, aggravated and assault, and, you know, didn't give Mr. Johnson a chance to affirm or deny the convictions. Would the result have been the same?
I don't think it would have come out any differently. I don't see why it would have come out any differently.
And then we're just talking about, in this case, then just a different reason why the sentencing enhancement apply. I mean, it
The
goes back to
sentencing-
a statutory.
It's a statutory interpretation question, whether or not that has guidelines implications, I guess is what I'm getting at. And the meaning of 1804A wasn't at issue in Johnson 1. I'm sorry, Johnson 2. If there are no more questions about that, I would like to turn to the statutory construction issue itself. So again, in looking at statute, when you do a statutory construction, you look to the law's structure, its plain language, and if those don't produce an absurd result, those control. And we can also look to the legislative history in determining whether it shines any light on anything. So the structure of this, A1 sets forth the basic premise: convicted of crimes committed on separate occasions. It has these consequences: an increased punishment up to and including 30 years. C1 is a definitional section, which says, what does it mean to have been previously convicted of 2 prior felonies? And it says, you shall be considered as having been convicted of 2 prior felonies if those convictions were on separate occasions. So this is what I think is the problem with one of the government's substantive arguments. You know, it offers 2 constructions that are mutually exclusive, but one of them is A1 is one way to violate or to come under the ambit of this. C1 is another way. But C1 doesn't contain, unlike A1, any consequences, right? C1 says you shall be considered, I want to get the exact language, person shall be considered as having been convicted of 2 felonies if twice before on separate occasions. But then so what? C1 doesn't contain any punishment or implications, unlike A1. So C1 is obviously a definitional provision. So one of the government's proffered constructions doesn't work for that reason. So then you come to the plain language after the structure. And as we put out a dictionary definition, as the Maryland court agreed and let, that the term 2 separate occasions has a plain meaning that's not fairly susceptible to an interpretation other than that of 2 unconnected, distinct, or unique times. 1 hearing, as what happened in this case.
So if we have 1 hearing on the same day and 2 separate case numbers, 2 separate prosecutions, and the court enters judgment on 1 before lunch, says we're breaking for lunch, see you in an hour, come back after lunch, enter judgment in the second case. Those are two separate occasions?
I mean, if it's one hearing and you take a recess for lunch in that hearing, yeah, that's one occasion. I mean, there's lunch breaks all the time and this
So the court says, so it's one hearing, reach the end of the day, it's too late. Court enters judgment on one of them, says, I'll see you tomorrow morning, come back, have another hour, enters judgment in the second one.
I mean, that's a continuation of, we're not this isn't, I don't think date-based or morning or afternoon-based. It's occasion-based and a hearing is a hearing, whether it lasts overnight or over the lunch break.
But then what makes it a hearing? Court has to call, I mean, that's just scheduling then, right?
I mean, the government's saying this is going to result in case one being called Monday and case two being called Tuesday, but that's just not the reality of what happens in Superior Court. As the government notes in its footnote 14, under Rule 101, cases such as Mr. Johnson's are put in front of one judge. Under the rules of the court, the same court-appointed lawyer is appointed in both cases. And in passing this law, the city council, we have to assume that the city council knew the practice in Superior Court of these global plea cases, such as Mr. Johnson's, that are called together and resolved together on one occasion, both for sentencing and imposition of, for the plea and then for the imposition of sentencing.
Why would,
But
go ahead.
I mean, my sense has always been that the reason why the defense always pushes for a single sentencing in two separate cases is that if they're separate sentencing proceedings and they're scheduled on separate days, then the second offense, the first crime gets scored and the criminal history score goes up.
For guidelines purposes.
Pardon?
For guidelines purposes.
For guidelines purposes. So
I mean, it's the practice in the court. I don't know about defense lawyers pushing for that. I mean, it's implicated by Rule 101 and just the general practice in Superior Court of global pleas being resolved on one occasion.
So you really want us to hold that that's not going to be compliant with 1804A? And so you want us to tell the Superior Court to start requiring defendants and defense attorneys to come back a week later or 3 days later, or what's?
I think
what's the law?
Superior Court's gonna keep chugging along the way that it always has.
Yeah, but what's your preference then on that? What's PDS's preference on that?
Well, I represent Mr. Johnson, not
Okay.
the Public Defender Service, but again, the practice in Superior Court is to have these global pleas resolved on one occasion. I don't think the court has to say anything one way or the other.
And
about
so
that.
why would that matter to anybody as to whether a recidivism statute applies, a repeat offender statute is implicated if something is held on the same day or after lunch or the next day or 3 days later? How is that possibly relevant?
I mean, so the question under statutory interpretation is, does it lead to absurd results? I think what the city council was getting at here, as we said in our briefs, is it's also interested not just in the fact of prior convictions, but also about chances to rehabilitate. And yes, there's going to be, the statute draws lines, and maybe it's not perfect in every instance. Maybe it's not ideal. I will admit the statute's not necessarily a model of clarity, but you have to interpret the words on separate occasions, as long as it doesn't lead to absurd results. And it's not always going to be perfect. It worked in this case, and it's going to work in the majority, I think, of cases in the Superior Court, given.
Let me ask you, Counselor, at the real heart of this, from your perspective, if we're talking about recidivism and that's the purpose of the statute, if the purpose of a criminal sanction, a punishment, is to deter crime in some kind of way, then the punishment has to be issued before we can determine recidivism. And so from your perspective, this idea of it being a day later or 3 days later, or even a week later is really irrelevant. It's about a new conviction coming after punishment for a previous conviction, correct?
I mean, I think that's one of again, if we turn to the legislative history, it's pretty sparse here and we don't really know what the council is getting at. But I think fairly construed, that's one of their concerns.
But
Yes.
from your perspective, that is the best way to read if we're going to talk about recidivism. I can't hold you responsible for something until I can't hold you responsible and start building up strikes until I've called the first one and established the strike zone for you.
That I think is one of the concerns of this statute, yes. And we know that from the language of C1, which again, tends to count opportunities for rehabilitation as opposed to purely the number of prior sentences. Does it get at it perfectly? No. Is it going to get it right every time? No. But is the common meaning of this term, does it lead to absurd results? I mean, I don't think so. No.
So if you want to stick with precisely the terms of the statute, then you would have to agree with the government that as a matter of pure physical action, if it's separate case numbers and separate prosecutions, not combined in a single judgment and conviction, that the trial court is, I know we don't have physical stamps anymore. Well, Judge Epstein knows better than I do, but the trial court is physically stamping two separate judgments on two separate occasions, right? Even if it's at the same hearing.
Yes.
So that's two separate occasions.
I mean, that's what the government says. I don't think anyone applying the common meaning of separate occasions would mean 2-second or however many, it takes to sign one and then to sign the other. That hearing is a separate occasion. That's what the Maryland court found in Lett, applying the common meaning of those terms. I think the government is parsing it way too finely. That's not the common meaning. And applying the common meaning doesn't lead to absurd results. And it's not going to lead to the sort of parade of horribles.
Well, I mean, it leads to the absurd result that if someone is not, if a trial court is not able to combine hearings on a specific day because they just don't, the judge just doesn't have enough time that day to do two. So one defendant is over two separate days and another defendant is combined, that those two defendants would receive substantially different sentences.
I mean, the
For
practice
the
is
same
to
conduct.
call both cases, and if it takes 1 day or 2 days, that's irrelevant. It's a continuation of
No,
the
but
same hearing.
I'm saying the first defendant, it's a combined hearing, which you have said is a single occasion. Second defendant, it's two separate days and it's more than a continued hearing. It's
Okay.
two separate days. Judge calls a new case number the next morning, clerk calls a new case number. That defendant is subject to a substantially greater sentence than the first defendant. Let's assume the exact same conduct.
I mean, again, this statute isn't perfect, but that's not typically what happens. I mean, under the way the government would have it, it would turn on the arbitrariness of whether, they could have charged Mr. Johnson under Rule 8 in one indictment. They chose not to. So theirs is really a case number based.
No, because their
approach to it.
interpretation turns purely on the separate commissions, the occasions of the commissions of the crime, which not the
Which right-
occasions of,
I'm sorry, which
not
right,
the, go ahead.
which rights, I mean, if that's their position, it really does write C1 out of the equation entirely. If all they're relying on is were the prior crimes committed on separate occasions.
No, because
Then
I
what
think
work
they've
does
posited
C1
an interpretation of C1 that is consistent with A1 or A, I'm sorry, but,
Let's say A1, yeah. I mean, they've posited two, the one that there's separate ways to violate it, which for the reasons I said before don't make any sense. And their second one is this space and time continuum, one that I think way too. It's not a fair construction of the word separate occasions. I mean, and again, we point to the dictionary, we point to Lett, we point to the Alaska case, Woolley, that we cited in our opening brief or relied on in our opening brief. I think they're just parsing that term way too finely. And I don't think if you ask the person on the street, was that one or two occasions, they would say that hearing is the one occasion. And again, even under their interpretation, it's going to turn on the existence of the arbitrariness of, do they bring a case like this in one indictment or in two indictments, or if they brought it together, does it get severed? This sort of case number based interpretation that the government has offered does lead to arbitrary and absurd results. Any further questions? I'll
We'll
sit
reserve your
down
time
and
for
come
rebuttal,
back to
Counsel.
rebuttal.
Mr. Lenners?
Thank you, Your Honor. Good morning, and may it please the court, Dan Lenners for the United States. The sentencing procedures that Judge Crowell followed in this case were identical to the sentencing procedures that Judge Rankin followed. And this court held in Johnson 2 that the defendant, when sentenced by Judge Rankin, did not receive an enhanced sentence for purposes of 1804A. It necessarily follows that the same defendant did not receive an enhanced sentence for purposes of 1804A when Judge Kroll sentenced him. And therefore, the defendant's argument is precluded by the law of the case. If the defendant did not receive an enhanced sentence for purposes of 1804A, then there is no possible due process violation because the conclusion that 1804 authorized a higher sentence above the otherwise applicable statutory maximum simply did not come into play. And just to go into the precise details, both judges did the same thing. They looked at 1804A. They said that based on the defendant's prior convictions, it applied, meaning it authorized the judge to impose up to 30 years.
I thought I read the transcript of the sentencing hearing before Judge Rankin, and I don't remember a discussion about it. 1804A.
The government on the initial sentence in 2011 on January 16th noted that it filed enhancement papers.
Yeah, the government's, but unlike Judge Kroll, Judge Rankin never said, you're exactly right about that. I agree.
He didn't in 2011, but then in 2017 at the resentencing, there was another long discussion of whether the enhancement applied. And defense counsel again said that the sentence, which was above the top of the guidelines that applied without the 1804 enhancement, was within the applicable guidelines with appropriate application of the enhancement. So, but both judges did the same thing. The government filed papers, argued for a sentence that was within the statutory range, but above the otherwise applicable guideline range. And both times the court sentenced within this higher guideline range. And this court said in Johnson 2 that that wasn't an enhanced sentence that implicated the procedural requirements of 23-111. So we think that that holding forecloses the defense's claim here. As to the government's alternative argument, as the court noted, Judge Kroll never said because 1804A applies here, I am enhancing your sentence. Judge Kroll simply said 1804A, his holding was that the defendant remains eligible for an enhanced sentence. The court then applied the guidelines and increased the range at the top of the guideline.
I mean, part of the problem is the meaning of enhanced, right? I mean, it's got a colloquial sense or an intuitive sense. I mean, and it's got a sort of a statutory sense. So Mr. Johnson's sentence was enhanced in some respect in the sense that, as you just said, his guidelines range increased, enhanced, synonyms, generally speaking. But when we talk about statutory enhancements, my understanding, especially with 1804A specifically, is we're talking about enhancements, meaning you have leave or whatever the term is to go beyond an otherwise applicable statutory maximum that's prescribed in the substantive statute. Right. So, I mean, I guess you would agree that we're not talking about what I just said, that in some sense, Mr. Johnson's sentence was increased based on an understanding of what 1804A means, right?
I don't think that occurred here. I think that could occur in a case. The court said, I understand 1804A to apply here, And even though I'm not going above the statutory maximum, I am nonetheless increasing your sentence because the council has singled your criminal history out as someone who deserves of a higher sentence. But that's not what the court did here. The court said you're eligible for an enhanced sentence. Judge
But so
Kroll-
but can I just stop you? If that is what had happened, or if that does happen, but it's not an enhancement above the otherwise applicable statutory maximum, would your argument still be that it's not cognizable? It's not a cognizable challenge in this court because it's still a guidelines issue?
I don't think so. I think if the court specifically said, I'm looking at this statute, I find that it applies, and the court's wrong about that. And it says, because the statute applies, I am directly increasing your sentence without regard to the guidelines, that would likely be a cognizable due process claim.
Even if it's within the statutory, otherwise applicable statutory maximum?
Yes, because I think the court would have gotten something fundamentally wrong. I see that as no different than getting a fact wrong, that the court says, because of this fact, I'm increasing your sentence. If the court got something fundamentally wrong and said, because of that, I'm imposing a higher sentence, that seems to be.
So that seems to be Mr. Johnson's argument here. I don't want to speak for him, but that's what I understand his argument to be. So now continue with your second point about why that's not what happened here, please.
So Judge Kroll below said he looked at what Judge Rankin had done, and he said, Judge Rankin did not impose an enhanced sentence under 1804A. This court held that in Johnson. And then he went on to say, well, is he eligible for an enhanced sentence? And he said, yes. And then he sentenced below what Judge Rankin had
Right,
sentenced.
but the premise that he wasn't sentenced to he wasn't given an enhanced sentence is only because it didn't go above the statutory maximum. I mean, that's almost like a legal fiction, right? I mean, it's by definition not an enhanced sentence because it didn't exceed the otherwise applicable statutory maximum.
But Judge Kroll couldn't have understood himself to have been imposing anything because of 1804A when he said Judge Rankin didn't impose this court held that Judge Rankin didn't impose an enhanced sentence under 1804A, and I'm now imposing a lower sentence.
Right,
But he did, but I thought he made clear that it was based on his interpretation of 1804A that he increased the guidelines range, and therefore the sentence that he imposed, which was lower than the sentence that Judge Rankin had imposed, but still above what would have been otherwise the guidelines range, was a guidelines compliant sentence. So it did actually affect the sentence because Judge Kroll said he was committed to imposing a guidelines compliant sentence.
So I don't think Judge Kroll said he was committed to imposing a guidelines compliant sentence anywhere. I agree that he did say, because 1804A applies here, my interpretation of the guidelines is that it goes, your top end of your range goes up. And then he gave a bunch of reasons for the sentence he imposed, none of which had anything to do with 1804A or the guidelines. I mean, he talked about, this is pages 27 to 28 of the sentencing transcript. He said the nature and circumstances of this offense illustrate the defendant's wholesale disregard for the justice system. He attempted to murder a government witness with a firearm. He said the defendant was paroled multiple times following his.
Those are all reasons to sentence at the top of the increased guidelines range.
Those are all reasons to impose a 20-year sentence regardless of the guidelines. I mean, he never mentioned the guidelines. He never said at any point that his sentence was somehow driven by the guidelines, that he otherwise would have not sentenced to 20 years had he thought the guideline range ended at 144 months.
But why did he talk about 1804A at all? Was it just it's kind of an interesting question. There's nothing at all to do, but I'm going to spend pages and pages and get additional briefing to resolve a question that has no impact at all?
Following the statement that we have to take the criminal history into account in all cases.
I can't speak for Judge Kroll, but he wanted to get the issue right, regardless of whether he used the power that 1804A gave him. The power that 1804A gives a judge is that they may, in lieu of any other sentence authorized, impose a greater term of imprisonment. He didn't use that power here. He did not impose a greater term of imprisonment than otherwise authorized.
But am I correct that the sentence that he imposed was above the top of the guidelines range that would have implied if 1804A had not applied?
Yes, that's correct, but that's a voluntary range. He was
Understood.
authorized to go higher under the statute, and he didn't do that. He didn't go above the statutory maximum for any of these.
But right, but under the guidelines, he only sentenced above the top of the otherwise applicable guidelines range after determining that 1804A permitted expansion of the guidelines range up to 360 months, right? I mean, 1804A is specifically cited in Appendix H as a reason to increase the top of the guidelines range.
I agree that that's factually what happened. The judge said that 1804A, that the defendant remains eligible for an enhanced sentence under 1804A. Then he said, because 1804A applies, I'm going to do my guidelines analysis and increase the top of the range. And then he said, I'm giving this sentence. And first, we think that's not an enhanced sentence under Johnson 2, and therefore the defendant's argument fails at the outset. The second is the guidelines aren't binding. So whatever he did to calculate that guidelines range, it doesn't matter because there is no error that the defense can complain of there. There's no cognizable error in increasing the top of the guidelines range. And then third, there is no direct link between this ultimate sentence he opposed and his choice to say 1804A allows me to increase the top of the guidelines range. There's nowhere in the record where he says that that made a meaningful difference to his sentence, that his sentence was impacted by his belief that 1804A applied. That the record is completely devoid of that. He doesn't mention the guidelines at all, other than saying, here's the guidelines calculation. When you look at the words he uses in imposing the sentence, he focuses on the nature and circumstances of the offense, the defendant's criminal history of having his parole revoked repeatedly, and murdering a government witness a few months after he was paroled. The court said that cannot be understated in terms of the severity in demonstrating a recidivist risks. So he found that this defendant posed a recidivist risk based on his actual factual criminal history, not anything about 1804A.
He certainly goes into great detail. I agree. And without commenting on some of the other very valid arguments that you're making, if we were unclear, where's the harm in kicking it back for clarity? I mean, I'm not sure even if we did so, we'd get a different outcome, but.
So, I mean, this question happens all the time in federal court where there's some guidelines argument and the court could have given the same sentence anyway. And one, it's a waste of judicial resources and government and defense resources to have a repeat sentence when there's no indication that the court would do anything differently. But also the defense has a burden of proving a substantial possibility that the court's error infected the sentence. And we don't think that substantial possibility is met here, given what the reasons Judge Kroll gave for giving his sentence.
I'd wanted to ask, I know you're getting close to time. I'd want to ask one follow-up question related to the question that Judge Schenker asked opposing counsel. I had actually understood the government's argument to be that if Mr. Johnson had been charged with the 2 drug offenses in 1999 and 2001 case, that 1804A would not apply. That it was the fact that it was 2 cases and not 1 that made it gave him 2 strikes instead of 1.
So interpreting, I think the answer is generally yes, that is our understanding. That there's an alternative interpretation of the statute that we posit in our brief that I don't want to focus on here today. But assuming that a defendant has to meet both A1 and C1, which is the Public Defender Services view, then he has to previously have been convicted of 2 felonies not committed on the same occasion. So meaning they can't be simultaneously committed crimes.
Everybody agrees, both sides agree that he
That-
committed two separate felonies on
Right.
separate occasions.
And then he has to have been convicted of a felony twice before on separate occasions. And so we understand that to mean two judgment and commitment orders. I don't understand why the defense is focusing on the hearing. You're not convicted at a hearing. You're sentenced at a hearing. But you are convicted. Your final judgment is when the judgment and commitment order is entered. And here there were two separate judgment and commitment orders entered, and they could not have been entered simultaneously. They were necessarily not at the same time. And that's how this court understood the word occasion to mean in Smith. It said the phrase on more than one occasion requires that the acts described have occurred at two or more distinct times, which requires some type of separation between the acts. And so there's necessarily some time separation between the acts. And we also think that that's a sensible reading of the statute. If you think about A1 is a factual question. Did this defendant have the opportunity to commit one crime and then some time separation before committing another crime? And then C1 is more procedural. Was there properly two cases that we ensure that the defendant had all of the procedural safeguards for? You know,
So in
whether-
your view, there's no real concern at all with punishment existing?
No,
Like,
Your Honor.
it's just the crime. So if there were hypothetically, instead of two in this case, there were three. And, even if they were heard together, there's now three separate orders. Based on the three separate occasions occurring, the trial court judge could do, okay, sentence on this one, and then on the last one, okay, because of the other two, now I apply 1804A and I can increase the sentence on that one.
I think that's right, although it's not clear to the degree to which the statute involves any sort of finality in terms of like finality on direct appeal. But I would point out that the court's question about rehabilitation and the council expressly took that requirement out of the statute. So before it amended it to its current version, the statute said that a person shall be considered as having been convicted of two felonies if his initial sentencing under a conviction of one felony preceded the commission of the second felony. So that clearly has a concern for allowing a person not to be considered a recidivist and to rehabilitate. You've been sentenced and then you made the choice to commit a second felony. But the council took that out. And so that is no longer the concern of the current version. In fact, it suggested an intent to eliminate that from the statute. And so again, we think the best reading is that factually, the offenses have to be committed on separate occasions, which we think could be a morning and an afternoon of the same day. It could even be 2 a.m. at different locations. If they're not simultaneous crimes, in both of those scenarios, the defendant has the factual ability to choose not to commit the second crime. And then procedurally, C1 makes sense as a protection of the defendant's procedural rights in court to require the entry of judgment commitment orders in 2 different cases to make sure that they are both procedurally sound convictions.
Can I ask you this? And I'm going way back to the beginning, but I just want to make sure I understand. 1804A allows for an enhancement up to 30 years. Is it the government's position that that a defendant convicted under any substantive offense that has a statutory maximum of 30 years is necessarily not enhanced under 1804A?
Yes, and that I think follows from this court's decision in, let me find it, I'm sorry. In the Morris case, 436A second at 377. There, this was the prior version, so it's 22104A, and it allowed for an enhancement up to life. And there, the defendant was convicted of a sentence below life. And the court said, section 22104A simply has no applicability where the offense itself authorizes a maximum life sentence. And so I think under that reasoning, the same is true now of a 30-year sentence under 1804A. There are no further questions.
Thank
Thank
you,
you.
Mr. Leonard. Mr. Gabus?
Briefly, as to the procedural question of the Johnson and, well, really the cognizable question, the government just conceded that if the judge misinterpreted statute and that it infected his decision, his or her decision, that would be cognizable as a due process claim. Government conceded that, and we think that's exactly what happened here.
But that goes to the question I just asked Mr. Lenners. I'm sorry to cut you off, but then I'll ask you the same question. What's your position on whether a defendant who's otherwise subject to a 30-year sentence is ever sentenced under 1804A?
In this case, below, everyone agreed that that baseline principle, yes, the government asked for the 1804 to apply. Judge Crowell
But
applied.
sorry, can you just answer that question? Because I really need to know it. If it,
Look, yes, under 1804A, it says shall increase the punishment up to 30 years. So it is a legislative thumb on the scale, greater or, I mean, the statute says increased. Everyone is using the word enhanced. Enhanced isn't anywhere in this. It's increased. And I think 1804A is a legislative thumb on the scale that people who recidivate, however you're going to interpret the statute, deserve an increased punishment up to 30 years. If the statute already allows for 30 years, then it's a thumb on the scale to increase it above what the judge might otherwise sentence the person to, had that judge not determined that 1804A applied. So I think the answer to your question, yes or no, I think is yes. And I think that the parties below treated it that way. We haven't briefed that, I don't think it's before this court. And again, if you want to be extra careful in your opinion, you could say, assuming without deciding that 1804A applies in situations such as this, as Judge Crowell obviously thought it did, then Judge Crowell erred and we need a new resentencing because he erroneously construed 1804A. I mean, Judge Crowell knew that he wasn't raising the statutory max, but he still wanted all this briefing to resolve the 1804A question, spent all the energy, as your honors have discussed, in his order resolving it, because he was going to follow that legislative directive to impose a quote greater sentence as deemed necessary under 1804A in light of a legislative determination that recidivists deserve a greater sentence. Very briefly, as to the substance, the government brought up the legislative history and that somehow this court should put a lot of weight in the fact that the language in Rogers, interpreted in Rogers, isn't in this statute. This is a complete rewrite. This isn't a, as often happens, this court issues a decision. The city council says we don't agree with that. It's recently happening in Cardozo. I know that there's at least one city council person has introduced legislation to undo or to scale back this court's en banc decision in Cardozo. We know what that looks like. I mean, Rogers was decided in 1980. 14 years later, in 1994, the council passes this law whose focus was, it's a complete rewrite, whose focus was allowing for LWOPs in some circumstances and requiring an LWOP in other sentences. Doesn't mention Rogers, doesn't say we don't like the outcome in Rogers, completely rewrites the statute, but does include this twice before on separate occasions, which it's our position is getting at a similar concern. Whether it gets at it as well as the prior statute did, maybe not. But again, the common sense interpretation of twice before on separate occasions does not lead to absurd results. And in fact, the government's interpretation does, because it makes it turn on whether or not there were two cases or one. And there could have been one case here too, and that seems like an arbitrary reason to deem someone a recidivist or not. So with that, we would ask that the court reverse and remand for a resentencing.
All right, thank you to all counsel for your argument and your briefs. This matter is submitted. We stand adjourned.